Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
Welcome to this, our weekend venued broadcast. My name is Jim Santelle, and yes, I'm your host. This hour and next hour on the broadcast stations of Civic Media. This is Amicus, a law review. We take our name every weekend from our adopted commission. And what is that? That's to conduct review and analysis, some deliberation, some consideration, and yes, often, as today, some criticism of the recent news of our times in the areas of law and government, and yes, indeed, the aspiration for justice in America. Amicus, of course, as we have chatted before, is a legal term. It's derived from the Latin. It's a term used to describe a friend, often a friend of the court, when it's added to the word curiae, amicus curiae, friend of the court. That's an individual, an organization, some entity that assists some way in understanding, in offering some appreciation, some assessment of relevant issues by offering some information, by providing some insight, some perspective, or some expertise in an area that may not otherwise be on that particular platform. This is indeed our mission, our goal here on this weekly weekend broadcast, and that also involves you, our listeners, on our weekend broadcast here on the broadcast stations of Civic Media. This weekend, as always, inviting your phone calls, especially your inquiries, your questions about the subject matter of our broadcast. That telephone number is 844-967-2789. Once more, 844-967-2789. My producer, Johnny, and I are here in the studios of WAUK, but taking your phone calls from across the state and beyond about those important issues in the areas of law and government and the aspiration for justice. Again, 844-967-2789. Be a part of our conversation, especially soliciting and encouraging your questions, your inquiries, as you always do, about the things that are on our syllabus, our plan for this hour and also for next hour here on Amicus, a law review. What is our plan? What is that syllabus, that academic agenda for this weekend broadcast? When we began with the recodification of our broadcast as Amicus, I promised from time to time that I would do something called case notes. That is a little bit more commentary, a little bit more observation, a little bit more opinion from my perspective about things that are going on in those areas of law and government and justice. And perhaps this morning, not so much in a break, but in a codification, in an invocation of that promise to you, spend a lot of time offering some perspective on one of the most significant things that has happened in our nation's history. It happened just last Thursday, April 25th. We're going to spend most of this hour and perhaps next hour as well talking about a major event in the history of our nation. Not to equate this with war, but it is in many ways a day that lives in infamy, as FDR said at the time that our nation was attacked at the beginning of World War II. A day in which our United States Supreme Court, the highest court in the land, the highest court in our land, entertained oral argument in a case called Trump versus United States. A case that raises what we have described on this broadcast and in others, a truly frivolous argument. A notion that is ridiculous, that is in some circles simply described as legal craziness, completely intolerable, unacceptable under any regimen, regardless of your political animus, your political perspective, your partisan views about the world, whatever that may be. A notion that our chief executive, the President of the United States of America, should be immune from prosecution for committing crimes. And up until last Thursday, again, this day that changes, puts us on course to change American history. Up until last Thursday, people on all sides of the political aisle, people much more learned than I, people in areas of law, but also not in areas of law, looked at this issue and said, certainly, the Supreme Court is going to make the decision not to pursue and not to embrace this truly frivolous argument that our chief executive under the Constitution, under some other accepted or unaccepted policy set, some notions out there that are unidentified, would be able to commit crimes and not be punished for those. Up until now, our Supreme Court has uniformly rejected those notions in ways big and small. And on Thursday, on what can only be described as a shocking, a stunning, a bewildering, and even revolting expression by majority members of the United States Supreme Court, seriously entertaining that notion. We're going to spend most of this hour parsing through what some members of the Supreme Court said on that majority. We're also going to be highlighting some things that the minority members of the Supreme Court said, also in abject disbelief about what some of their brethren and sistren on the Supreme Court were saying. We're going to parse through all of that and indicate along the way that these kinds of arguments made along the way by advocates for, yes, Donald Trump, these notions that somehow invested in our Constitution is a protection for the chief executive so that he or one day she cannot be prosecuted for crimes committed in that setting. That notion, shockingly, surprisingly, stunningly bewildering, is being seriously entertained by the highest court in our land. We're going to talk about all of that, the things that brought us to this point, and we're going to talk also about what's going to happen in a few weeks, 6 short weeks. The United States Supreme Court going to be deciding some 44 remaining cases on their docket of 62, this among them. This is not investing in the distant future. At some point in the next month and a half, the United States Supreme Court is going to tell us whether or not they are serious about this notion that executives, the chief executive of our nation, can in fact commit crimes and do so with impunity. We will talk all about that and again invite your questions. The call-in number this morning, 855-752-4852. All of that as a part of the discussion in this first hour and the second hour as well. We're also going to spend some time talking about the all-important trial that continues. We're going to focus upon some of the trial testimony, yes, in that Manhattan courtroom in which a candidate for the presidency, Donald Trump, is presently on trial for crimes in violation of New York state law. Charges against him. He is presumed innocent until proven guilty. We're going to talk this hour and next hour, more likely, about the impact of the first week of trial testimony in that case, focusing undeniably upon the key first witness, and discuss why it is that that witness was so very important in setting the stage for a jury understanding of all of that. And then talk also about some other witnesses who are on the stand as late as Friday of this past week, who begin to flesh out much of that as well. We're going to talk about why those witnesses are so very credible. We're going to talk about the impact of the statements made, the accounts provided by this gentleman named David Pecker, the former publisher, yes, that's right, of the National Enquirer. We're going to talk about the candor that he brings to the testimony that he provided, the credibility, the corroboration for the account that is being provided by the district attorney, Alvin Bragg, in that prosecution. A very strong start this past week in the presentation of that trial testimony in the court in front of that trial jury. As that trial continues in the coming week, we'll also talk about the schedule for this coming week, and we'll talk about yet another hearing that the presiding judge, Judge Juan Merchan, is going to have on this issue of whether the defendant, Donald Trump, continues to violate the terms of the basic fundamental order that applies to him and to every other defendant in any other case in the United States of America, including right there in New York, that prohibits him from commenting upon and criticizing witnesses, commenting upon and criticizing members of the jury, commenting on and criticizing other members of the court staff, not including, interestingly, the judge and the prosecutor themselves, but prohibiting statements made in the public domain that would undermine the conduct of justice, the delivery of justice in that setting. And so for all of that, principally in our second hour, discussing that all-important trial, and then, time permitting, we're going to be talking about other matters that under any other circumstance on our Saturday and our Sunday morning broadcast, our weekend broadcast here on Civic Media would take the lead. Matters related to the overturning of a conviction of Harvey Weinstein in New York by an appeals court for his sexual crimes committed with respect to women victimized by him. We would talk about that as our lead under any other circumstances, but for the seriousness of these other matters. And that too, that story as well, hugely important in not only understanding that case, but also for the administration of justice. We would also talk about what happened in Arizona this past week when, yes, charges were brought becoming the fourth state as opposed to a federal authority, bringing charges alleging election interference, not only against people who were involved in trying to overturn the results of the election in Arizona, but also the fake electors there as a part of that conspiracy. Depending upon time, we may get an opportunity to talk about that as well. All of these hugely important cases and matters, but we begin with what is arguably, and from my perspective, undeniably, the single most important story, not just of this week, but of this year, and arguably for our time, depending upon what the Supreme Court does. I'm going to talk about the narrow possibility yet that the Supreme Court could still get this right and pull us back from the horror, if you will, that they articulated on Thursday about the possibility that a sitting president can commit crimes while in office and do so with impunity, without any response from any law enforcement. That is what a majority, 6 members of our Supreme Court, entertained seriously in this argument in connection with that oral argument, Trump versus United States of America. It is a case that goes to the fundamentals of the rule of law. It applies, frankly, to all aspects of our government. And if they follow through on it, it also presages what could be the beginning of the end of the fundamentals of our constitutional system. We talk more about that this weekend on Amicus, a law review. This is Amicus, a law review, our weekend review of major stories in law, government, and the aspiration for justice. My name is Jim Santelle, your host for this hour and next hour here on the broadcast stations of Civic Media. Delighted to have you joining me this weekend for our broadcast. Also inviting your live call-in to me, to my producer, Johnny, here in the studios of WAUK, taking especially your inquiries and your questions about the subject matters of our syllabus this weekend. That phone number, once again, is 855-752-4852. Once again, 855-752-4842. Or you can also text Johnny and me at the Civic Media app. Send us your comments, your questions, and we will also entertain those in this, our weekend broadcast. I promised that we would spend most of our first hour, perhaps even a portion of our second hour, because of the importance of this topic, on this major Supreme Court oral argument that the members of the Supreme Court scheduled and conducted on, yes, the last day of their oral arguments of this term. This is the 2023-2024 term. The very last day of this term, the United States Supreme Court entertained oral argument. No more oral arguments for the rest of this term. They'll begin that again in October of this year with the new term, 2024-2025. But we are now done. with oral arguments in all of the cases, 62 of them altogether. They've already issued opinions in 18 of those, and we have highlighted some of those in recent times. We'll talk more about this entire group of cases that the Supreme Court will be deciding in May and in June, including certainly this major case that they entertained on Thursday of just this past week. Now, how does it come about? How does this case come about? Let's set down some foundational issues here. Donald Trump, during the course of his various litigation involvements, including especially the case that is pending against him in the federal court in the District of Columbia, the trial court there, a court that is presided over by Tanya Chutkan. She is the trial court judge. And along the way, in the prosecution of that case by Jack Smith, a 4-count indictment alleging election interference by Donald Trump, an attempt not only to overthrow the results of the 2020 election, but to do so in a way that's criminal under the law as charged in that indictment. Donald Trump raised the issue that he is immune, completely, broadly immune from prosecution. And Tanya Chutkan, months ago, in a very compelling, lengthy opinion, analyzed every aspect of that argument and issued, again, a hugely compelling, convincing written order in which she rejected that notion as contrary not only to contemporary understandings about the rule of law, but also to our foundational predicates in the Constitution, things that James Madison wrote about in establishing the second article, the executive branch of our Constitution. She rejected all of that. And Donald Trump, as is his right, took an appeal of that decision to the United States Court of Appeals to the District of Columbia Circuit and said, I'd like you to review this case. I'd like you to review the rejection of my position by the lower court judge. And the Court of Appeals took that on. And yes, after a month of deliberation, much too long, but nonetheless, they too came back. Another hugely compelling, somewhat lengthy, but very compelling, very readable, very digestible opinion, found the same thing. I commend to your attention, as we think about what happened this past Thursday, the very compelling, learned, thoughtful, balanced approach of Tanya Chutkan and the Court of Appeals dismissing this frivolous, completely unfounded argument that somehow the President of the United States of America should be completely blanket immunity for the things that he does in the Oval Office, and arguably beyond the Oval Office in the execution of duties as the President of the United States of America. The special counsel immediately asked the Supreme Court, frankly, even after Tanya Chutkan had decided the case against Donald Trump, asked the Supreme Court to take this case on, to jump over the Court of Appeals because of the need to get a resolution of this and to get this underway so that Tanya Chutkan, who has now suspended the trial of those 4 counts in front of her, waiting for a Supreme Court resolution of this. Jack Smith had asked the Supreme Court to take that on. The Supreme Court early on said no. Let this go through the process and extended further the deliberative review by the judiciary. And although that decision, that procedural decision, certainly is subject to attack, certainly delays the process by which this matter gets to trial, much to the frustration of the Department of Justice and Jack Smith and many Americans who look forward to the trial of this matter in a federal district court in Washington, D.C., even though that process was not embraced, the process proposed by Jack Smith. The Supreme Court ultimately did grant certiorari, which means they did agree to review then the Court of Appeals decision, finding as well as every other court in this country has found that the President of the United States of America does not have immunity for crimes committed, took that position and took that argument on, ordered briefs which have been filed, a part of the regular process in the wake of granting a writ of certiorari, and went down this road and scheduled this special oral argument, added on this additional date this past Thursday, April 25th, to entertain oral argument on this notion. Frequent listeners to this broadcast and other broadcasts on the civic media stations know well that I and most other people in the areas of law and government justice who are entertained by the notion of having serious arguments about the law and about what the Constitution means, what the statutes that are passed under it means. All of us out here looked at this and said, certainly there is no doubt that the Supreme Court is going to do exactly what the lower courts have done, what Tanya Chutkan did, what the D.C. Court of Appeals did, and reject this notion summarily. And the notion behind that, the reason why I articulated that view on this broadcast and in others, was of the absolute certainty that that had to be the right decision. Not only is it implicit and explicit in our Constitution that there is no such concept set forth by our founding fathers, but if it would to be adopted, grafted on somehow into the jurisprudence of our nation, it would indeed be the beginning of the end of our republic. Because we would then be returning to exactly what prompted, almost 250 years ago, the Declaration of Independence. That is the rejection of a king who does indeed have, as King George did at that time, unfettered discretion to do what he wanted without any possibility of criminal prosecution. That's precisely what this nation was founded upon. That's precisely what the founding fathers rejected in 1776, 250 years ago, and upon which all of our jurisprudence since then has rested. 6 weeks from now, sometime in the next 6 weeks from now, it is entirely possible, based upon what we're going to talk about next, the Supreme Court may reject that fundamental notion and may indeed be setting us then on a course toward the ultimate chasm in the very fabric of our republic. We talk more about that and what the Supreme Court said on this weekend broadcast on Amicus, a law review. This is Amicus, a law review. My name is Jim Santelle, and yes, I am your host this hour and next hour as we talk about this momentous, cataclysmic thing that happened in Washington, D.C. just this past Thursday. That is the oral argument in this case called Trump versus United States, in which the Supreme Court was entertaining, apparently seriously, for the first time in our nation's history, 240 years of history, the notion that a chief executive, the president of the United States of America, can commit crimes and not be punished, not be responded in some way to based upon that criminal conduct. Indeed, in the wake of the oral argument, some of the more tepid headlines in America said things like, conservative justices appear poised to rule that presidents may have some level of immunity from criminal conduct. That is understating dramatically the significance of what happened on Thursday. Now, I will tell you from my own personal perspective that I fully anticipated that once the Supreme Court would entertain this, schedule this on for oral argument, this court would do what I've seen other appellate courts do, other practitioners do, when in fact they already know what the result is, when they have basically decided the case based upon the briefs, their understanding. I've had many circumstances, civil and criminal cases both, argued to the Federal Appeals Court in the Seventh Circuit, when if you stand up in front of the court and you are not questioned, you're not quizzed about something significant, you probably have a good sense that the court before whom you are appearing, the judges on that panel, have a pretty good idea, if not a certainty, about where this case is going. And usually you can predict exactly what is going to happen. And so one of the concerns that I had initially when listening to the oral argument on Thursday of this past week was that it appeared that the Supreme Court was giving legitimacy in even its first moments, even its first half an hour of nearly a 3-hour conversation about this frivolous concept, giving legitimacy to this notion by the very fact that we're not simply listening quietly to an absurd argument being made by non-serious lawyers in this matter, but entertaining seriously, seemingly cloaking this argument in some aura of respectability, based upon questions back and forth, and sending the first of some very bad messages to America. Sending the message that this, like those other 61 cases that are out there, is somehow on the same level, on the same plane, that we are examining here interpretations of the statute, of a law, of a decision made by a lower court, and analyzing it according to standards that reasonable people can disagree on. And as the oral argument continued, my initial concern was that we are sending a message that this is normal, that this is regular, that we should simply regard this argument, like all the others, as being one on which reasonable people can disagree, and that is not the case. This is and always was and always will be, depending upon the future of our nation, a ridiculous, frivolous argument, and by virtually extending this oral argument, engaging what appeared to be academic, intellectual, university type, law school type examinations, sending the message, even putting aside the substance of those, some of which we'll get to, even putting all of that to one side, the notion being sent to America was there was something real here. And that's the first major problem with what happened on Thursday. It is eclipsed. It is overcome by the substance that followed. And indeed, we know what did in fact follow. To cut immediately to the chase, the takeaway from the 3 hours, nearly 3 hours of oral argument is that at least 6 members, certainly 4, maybe 5, maybe 6 members of the current Supreme Court are heading toward a regimen where you can discriminate against certain kinds, discriminate among certain kinds of criminal behaviors of a chief executive based upon whether or not those behaviors are classified, characterized as personal in nature, individual in nature, something that the president did in his or her personal capacity, as opposed to official capacity. And based upon that distinction, somehow, you would carve out, presumably, a set of things, a set of pieces of conduct, of behaviors in an official capacity that would not be subject to the criminal law. That is a not just stunning, but shocking notion. And that discrimination, if you will, between private, personal activities and official activities is what animated much of the discussion. And it appears, once again, to cut to the tea leaf chase on all of this, that may well be what the Supreme Court is wrestling with right now, identifying if it is at all possible, and I would offer to you it is not possible, to discriminate against and define the ways in which some conduct can be personal and some of it official when you're talking about a president who is exercising official capacity, duties, and responsibilities every day and night. Nonetheless, it appeared that concept animated much, if not all, of the exchange. Now, along the way, to their benefit, including an exchange with Amy Coney Barrett, among the 6 who seem to be heading in this direction of asking the lower court to parse through this indictment and figure out which elements are personal and which elements are official, and therefore divide those out and find that only the personal matters can be the subject of a criminal prosecution. Along the way, Amy Coney Barrett and others did confirm their view that an omnibus, complete blanket immunity, is not a possibility. And so they rejected that fundamental notion being articulated by Donald Trump and his non-serious attorneys before the United States Supreme Court. And that is, I suppose, the only small droplet of good news that comes from this otherwise horrifying oral argument of this past Thursday. Because we know almost certainly the Supreme Court will not adopt that. But again, reading the tea leaves, it appears that they are on this road toward distinguishing among criminal acts those that are official in nature under the Constitution, things expressly given to the chief executive terms of duties and responsibilities, and those that are exclusively personal. Well, we know based upon our discussion on this very broadcast, concepts reaffirmed by the outstanding Solicitor General, the Deputy Solicitor General, a fellow named Michael Dreeben. Michael Dreeben. He articulated this view that this is not one of those situations, if there's ever a situation at all, where you can distinguish between those two kinds of things. They are all mixed. He described this as an integrated conspiracy to undermine the electoral votes in 2020. An integrated attempt by the president exercising official capacity things, including, for example, trying to direct the vice president not to properly certify the votes, directing the Department of Justice through the Attorney General, the acting Attorney General, even someone who would be the Attorney General, directing the Department of Justice. Those may be official capacity exercises, but doing that plainly out of the personal interest in keeping in power, remaining in power, keeping the presidency to his own, usurping the very will of the people. And Michael Dreeben, again, this outstanding Deputy Solicitor General, arguing on behalf of not just the United States of America, not just the Department of Justice, but also reason and rationality, came forward and said that is an untenable approach. And if you send this back down, my words, not his, to Tanya Chutkan, she will not be able to parse through this because they're all integrated. You cannot distinguish one from the other. And indeed, that's the very reason why the grand jury, 26 people, not the Department of Justice, not Jack Smith, not Joe Biden, not the Attorney General, but a grand jury found probable cause to believe that that integrated conspiracy did in fact exist. And yet the United States Supreme Court, finding a way in this stunning oral argument, nearly 3 hours, to distinguish between official and personal acts, and apparently going to describe in some way, contrary to what the express argument was from the government, contrary to the best interests of our nation and its future, that indeed there is a way of doing this. Now, along the way, as I said, the Supreme Court, virtually every member, acknowledging that a blanket immunity cannot apply, but nonetheless giving life to what can only be regarded this past Thursday, at least at a minimum, as an interim victory for Donald Trump. He has got to look at that appellate panel and say, gosh, 6 members of that appellate panel have already said that there is something to this argument. There is something to this argument that everyone else on reason of all sides of the political aisle have dismissed as being ridiculous. Donald Trump, in the wake of that oral argument on Thursday, looked to the Supreme Court, and yes, indeed, he appointed 3 members of that Supreme Court, looked to that Supreme Court and said, there is a question here that these members of the Supreme Court are seriously entertaining and sending the message to America again that there is a serious question here when there is not. And indeed, beyond that, that this Supreme Court may at some point in the next 6 weeks, not months from now, but the next 6 weeks, articulate a view that accomplishes something that Donald Trump wanted, which is an identification, a carving out of some kinds of criminal behaviors by our chief executive that will not be subject to prosecution when, in fact, there is an alleged violation of law by here a grand jury. So let's get into it. Let's talk about what the Supreme Court said inside that broad rubric. We know from the start that the Supreme Court was identifying the serious nature of this. Neil Gorsuch saying we are plainly writing a rule for the ages, and indeed, that's what the Supreme Court is going to be doing. This is the law of the land. This is not musing on the future of our nation. This is a directive of what the law is, obliged to be fulfilled and followed by lower courts, including the D.C. Court, including by the D.C. Court of Appeals, the lower trial court. Justice Brett Kavanaugh is saying this case has huge implications for the presidency, for the future of the country. Yes, it does, Justice Kavanaugh. It's going to cycle back and be used against the current president or the next president. And that's where he gets into some of the arguments that, again, are frivolous and are not meritless, and nonetheless adopted by this court, at least a majority of its members, in going ahead and finding that there may indeed be a carve-out to some of this. Justice Brett Kavanaugh, again, articulating this view further advanced by Sam Alito and others, suggesting that some form of criminal immunity, if that is in fact embraced by the majority here, that former presidents would be vulnerable to partisan warfare as their successors used the court to go after them once they were out of office. And that, Sam Alito added, could lead to endless cycles of retribution that would be a risk to a stable democratic society. What he's talking about there, in frivolous terms, is this notion that somehow we would have repetitions of something that has never happened until now, until we've had a chief executive who's engaged in criminal conduct, that on a regular basis, when every single president leaves, the following administration would then indict that person for who knows what. Criminal conduct, maybe non-criminal conduct, and that would be a risk to stable democratic society. I would offer that that perspective is cynical, that the Supreme Court Justice Alito fails to understand the grand jury process, that we have people in positions of responsibility who do not bring cases, who do not charge cases against a former president or anyone else, absent probable cause, doesn't understand the grand jury process, doesn't understand the oath of office that investigators and prosecutors in the federal system, the state system, the local system take to uphold the Constitution and do it in a sensible way. And then Sam Alito goes on to posit another possibility, and that is that this very possibility of immunity would prompt a coup by the executive who would remain in office through a coup to avoid that very prosecution. Also absurd. Never before happening, of course, in our history, but positing this hypothetical for which there's no historical precedent. And in terms of the possibility, this is Amicus, a law review. My name is Jim Santelle, and yes, we're talking about this stunning, this shocking oral argument before our United States Supreme Court of just this past week, this on our weekend venued review of issues related to the future of America and the administration of justice in our country. During the course of this oral argument, as we have been commenting all this weekend, we have members of the Supreme Court making this distinction between personal acts and official acts. Brett Kavanaugh saying the president is subject to prosecution for all personal acts, he said, just like every other American for personal acts. The question, Brett Kavanaugh said, is what about acts taken in an official capacity? That is the distinction the Supreme Court is articulating, at least from the bench. And along the way, Justice Amy Coney Barrett also then says, even as she acknowledges that a blanket immunity is not a possibility, she says, can't prosecutors simply drop Mr. Trump's arguably official actions from their case? She's talking about these 4 counts pending in the federal district court, returned by the grand jury, and proceed to a swift trial focused only on his private, his personal actions. And of course, Deputy Solicitor General Michael Dreeben, again, I commend to you to listen to this man. And I must tell you how proud I was to be a former part of the Department of Justice, listening to this advocate, not just for the Department of Justice, but for you and for me and for everybody else, pushing back on that notion. He said this, he said the indictment against Mr. Trump lays out an integrated conspiracy in which Donald Trump took the official actions and went on to say to bolster the chances that his personal situation would be advanced if the election was overturned. Again, indicating this interconnection between personal and official actions, a distinction that makes no sense. And yet, along the way, virtually all of the members of the majority appears in the Supreme Court, the 6 of them, articulate various versions of what Sam Alito described. That is this prospect, this specter, that somehow if there is immunity, we would have these series of post-incumbency lawsuits, probably criminal in nature, brought by the next administration against the prior administration, something that has never happened in our history. And then also that would actually encourage a coup by the very person who remains in office, afraid that when he or she leaves office, he would be subject to that. Those kinds of hypotheticals offered by Sam Alito, a justice of the Supreme Court, I would offer to you are not only contrary to our basic concepts of rule of law and justice in America, but I must tell you that I was offended by them. Along the way, the Associate Justice Sam Alito engaged in this exchange with the counsel for the Solicitor General Michael Dreeben, and along the way, Sam Alito talked about the fact that in our country, a grand jury will indict and can indict a ham sandwich. Now, those of you who've listened to me on this broadcast on a regular basis know that I have routinely rejected that and objected to that assessment. It has been my experience that grand juries take their responsibilities very, very seriously, that they do their work conscientiously. I did this off and on for 30 years of my time in the Department of Justice. And indeed, you're listening right now to a former prosecutor who, on more than a handful of situations, was told by members of the grand jury that they want more information, they want more evidence before they come to a conclusion. This is an independent, deliberative body. And yes, on a very few occasions came back to me and said, Mr. Santelle, we do not concur that there is probable cause. That is not a body that indicts ham sandwiches, Sam Alito. And how dare you describe grand juries in that fashion? When Michael Dreeben pushed back against that and said, no, Mr. Associate Justice of the Supreme Court, that is not the concept. And we've got reasonable people in these positions, prosecutors, U.S. attorneys, confirmed, by the way, by another branch of government, nominated by the president. We've got people who are responsible and who are decent in upholding their oaths of office. When Michael Dreeben pushed back on that concept, Sam Alito didn't let it go. And he said, well, an eclipse happens from time to time, meaning every so often, maybe the grand jury does get it right. That is cynicism of the highest order. And it concerns me greatly, that from him and from others on the bench, we have that sense of our government that is not responsible, that will be acting in a way that will not only be contrary to the best interests of our nation, but contrary to the oath of office, contrary to the Constitution itself. Now, along the way, yes, indeed, we had three members of the Supreme Court who pushed back on all of this, pushed back on the Neil Gorsuches, pushed back on the Amy Coney Barretts, pushed back on the Sam Alitos, and said, wait, you can't be serious about this. Isn't the greater concern that we will have someone in the office who engage in criminal acts? Ketanji Brown Jackson, among the other two on the bench, appeared most concerned that if presidents were in fact shielded by this kind of immunity of any kind, whether there's a distinction between official or otherwise, they would be unbounded by the law and could turn, as she said, the Oval Office into what she described as the seat of criminality. The seat of criminality. And contrary to what Sam Alito said about risking a stable democratic society, it was Sonia Sotomayor who took that up and said just the opposite, that if you want a stable and democratic society, you need necessarily to ensure that everyone is subject to law, that no one is above the law. Michael Dreeben picking up on this same theme, envisioning just the opposite scenarios of what six members of the Supreme Court were articulating. Mr. Dreeben worrying about that any form of blanket immunity, or even less than that, would place presidents entirely outside of the realm of the rule of law and encourage them, as he said, to commit crimes, including bribery and treason and sedition and even murder with impunity. And stunningly, when some members of the Supreme Court quizzed John Sauer, who is representing the defendant, Donald Trump, in this matter, on whether or not those kinds of criminality, that kind of behavior, could in fact be committed by a sitting president with impunity, he refused to say that there would be prosecutions. And from his view, indeed, that the blanket immunity for which he was advocating would permit that kind of violent crime, including murder, including sedition, bribery, and treason. That was a part of the reasonable, rational oral argument that the Supreme Court was conducting this past Thursday for nearly 3 hours in front of the people of the United States of America. When we come back in our second hour, we're going to take some of your calls and comments at 855-752-4842 and talk more about what the Supreme Court did and did not do on Thursday in this. This is Amicus, a law review. My name is Jim Santelle. I am your host for this, our second hour on our weekend broadcast, doing a very careful and deep analysis of what happened in our nation's highest court this past Thursday, oral argument in Trump versus United States, in which the Supreme Court stunningly, shockingly, revoltingly began to entertain the notion that there is indeed a package of pieces of conduct, behaviors in which our chief executive can partake, can do, that would not be subject to prosecution if they're crimes. And the majority, it appears, of the Supreme Court articulating this difference between personal notions, personal behaviors, and official notions, official behaviors, as a way of describing that in some fashion. Along the way, we had appropriate pushback from Ketanji Brown Jackson, raising the specter about the possibility of turning the Oval Office once again into the seat of criminality if, in fact, you give a president complete immunity or something short of the affirmance that you can, in fact, be prosecuted for crimes that you committed. Along the way, Sonia Sotomayor also asks about the limits and the extent to which these immunities would attach. She says, what if the president were to order the military to stage a coup? He is the commander-in-chief and orders the military to stage a coup to keep herself in office, plainly for a personal benefit. She also asks, what if the chief executive orders the assassination of a rival? Is that the kind of thing that could be accomplished with impunity? And stunningly, once again, John Sauer, counsel for Donald Trump, says it depends on the circumstances. No, it does not. No, it does not. And Sonia Sotomayor and Ketanji Brown Jackson, and yes, Elena Kagan, underscoring this fundamental notion. Elena Kagan, a spectacular job in saying this. The framers understood. They knew how to do immunities. They knew how to accomplish immunities in state court constitutions. They didn't do it here. There is nothing in this Constitution, just the opposite, Nothing in this Constitution that says that there is an immunity of any kind, of any dimension. They didn't do it. They knew how to do it. They expressly did not do it. And goes on to affirm once again, the president is not above the law. Again, implicit and explicit in every single page of our Constitution. And she says, wasn't that the point? Wasn't that the entire point of rejecting the king in England? Wasn't that the point? And she then invokes, as do her other colleagues, Sonia Sotomayor and Ketanji Brown Jackson, this all-important language in Article 2, nestled near the end of Section 2 of Article 2, that says that the president shall take care that the laws be faithfully executed. The laws be faithfully executed. That's the take care clause that we have often talked about on this broadcast, underscoring the significance of what that means. If the President of the United States of America is obliged to take care that the laws be faithfully executed, and yet he or she, himself or herself, as to his or her own conduct, can engage in violations of those very laws that he is or she is obliged to take care that they be enforced and executed, does not that stand the Constitution on its head? And as I have offered, begin to crumble the very foundations of our tripartite branch of government, where we've got executive branch, we've got a legislative branch, a judicial branch. If we have an executive not subject to the rule of law in America, we are beginning not only to undermine the language of the Constitution, but to bring to a conclusion, a close, this 240-year experiment in democracy, a republic in our nation that is threatened now by this argument and the embracing of a partial, if not complete, but a partial immunity for crimes committed by an executive in office. That is what brings us to our callers calling in at 855-752-4842. You can call in. You can also text us, and you can also use the Civic Media app to engage in this, our conversations, our questions about what's going on with the Supreme Court. We're going to begin with Joe. Joe, glad to have you with me once again this weekend on our broadcast. And Joe, do we have? Yes.
Really, thank you. I appreciate this. It's really a detailed and I appreciate the passion with which you're speaking when you use words such as "this is a horrifying situation." It gives us a sense of the catastrophe that's ahead if the president is not subject to the laws of the nation. I mean, of course, it's going to become a crime center. I mean, if I were a criminal, I would say, "Geez, good time, good pickings. Get myself elected president by any means necessary, and watch out." A question I would ask for you is that at present we're talking about the chief executive. What's to say if the Supreme Court says, okay, there's the president, the executive does have immunity for acts that we may consider criminal, such as murder or a coup or bribery. What's to prevent that from filtering on down to the executives at the governor's levels? I mean, there's a lot of contracts or appointments that are made. One could say, in the same way that they were looking at ambassadorships and saying, well, if you took a bribe to get someone who wanted to be an ambassador, would that be a personal or would that be an official act? It seems to me that it's opening up a can of worms that is never going to be closed if you have this partial immunity, because people are going to try to parse out how can I do it? What can I attach to my act to make it be official, and thus I would be free from any consequence. So I'd be interested in your reaction to those 2 points. What if it goes down to the executives at the gubernatorial level? And what if you then have people who are just seeking any little loophole, any back door, any off-ramp to get them out of a charge by attaching official duties to it? So I'd be curious what your reaction is. Thanks, Jim.
Joe, as always, very important questions. And along with Michael Dreeben, I'd offer, Joe, that you and other listeners should be right there, raising those kinds of specters, ghosts, the possibility of terrible things happening. Yes, indeed, the courts can appropriately be thinking about the next case. And along the way, before I get to the specifics in response to your very good questions, Joe, I would offer that this is not a Supreme Court that wanted to listen to the specifics of this case. They wanted to entertain the future, the possibilities of the implications of their orders. And again, appellate courts often do that. They think about the next case, the next issue, Mr. Santelle, that we need to wrestle with, and how should we craft a standard that will address not just this case, but down the road. That process in and of itself about what happens, the consequences, is not inappropriate for an appellate court. The difficulty, of course, here, as you listen to this oral argument, is the majority wanted to hear nothing about these particular facts, the particular allegations against Donald Trump, notwithstanding Michael Dreeben's consistent attempt to do so, but wanted to pose all sorts of hypotheticals, including of the sort that you raise. Let's talk about these loophole options. Michael Dreeben and others, even in the wake of this oral argument, asking about how do you define, and this goes to the core of your points and your questions, Joe, how do you define this distinction? I think one of the people in America who should be most concerned about what happened on Thursday is, in fact, Tanya Chutkan. She is a district court judge who presumably is going to be on the receiving end of some sort of order coming up in June, telling her with some standards, perhaps, maybe, or maybe not, that she needs to parse through this and figure out which among the charges, the pieces of evidence presented during the course of the trial, which of those are official, which of those, in fact, could be identified perhaps as a loophole, Joe, as you identified it as well, and could be falling in one bucket as opposed to another, a bucket of personal behavior as opposed to official behavior. The process is virtually impossible to do, even inside of a system of jurisprudence that contemplates standards all the time. and we do establish standards, I wonder out loud, as does your second question, about the possibility of identifying what's on the left side of the line, what's on the right side of the line, that prospect that you've got future presidents trying as best they can to stay on the appropriate side, and I say appropriate in quotes, only because if it is criminal activity, it should be subject to prosecution. But trying to find those loopholes out there, depending upon a standard that cannot be properly understood and cannot be properly articulated. Tanya Chutkan must be very concerned today about the job that she may be getting from the Supreme Court in trying to address those kinds of things. The first point you make, Joe, about the collateral consequences of this, if indeed there is immunity in a president, for whom else, right? We do always think about the next case. Does the next case involve a governor? Does an estate proceeding, admittedly a state matter, not a federal matter, and there's a distinction there, and there could be that argument made about the applicability of state versus federal matters, but could someone on behalf of a governor say the United States Supreme Court, the Supreme Court of the land, has described the authority of a chief executive, much like a governor, much like cabinet officials, whether federal or state, much like any other agency folks out there who might have impunity when it comes to the kinds of things that the Supreme Court is talking about. That's the concern, too. Even if you articulate in some wildly imperfect way, wildly unclear way, what is the consequence down the road beyond just the presidency? Today, this week, and in the next 6 weeks, and perhaps beyond that, we focus especially upon the consequences of this for our republic and the consequences for the presidency, for which we're selecting a new incumbent come November, or a next incumbent come November. Very important points, very important observations to make, Joe, about the consequences of all of this. We also have on the phone Jean from Eau Claire. Jean, glad to have you calling in our weekend broadcast. And I think we've got Jean. Yes, Jean, go ahead.
Oh, thank you. Okay, thank you so much. Thank you for taking my call. I was mortified when I watched live. I took a lot of notes, and there were a lot of themes that kept going through their questions. And, presidents on duty like 24/7, the crimes were committed against us. What about crimes of treason when a president is on duty? Can he commit treason? Also ordering the military to attack others within our country. He can make up his own laws as long as they're in his official capacity. I think that this is ludicrous. And also, this is a president that put those people on the stand when they didn't always tell the truth, and I watched them when they were questioned by the Senate, and they said other things than what was true. So I hope there's ideas of what we can do as a nation to fight back on this. Thank you so much for all the things you're doing, because a president's on duty 24/7. And if he does commit a crime, he could say, it's been my official.
This is Amicus, a law review. My name is Jim Santelle, and yes, I am your host on this, our weekend review of issues related to law and government and justice in America, focusing especially, almost exclusively on this weekend broadcast on this stunning oral argument in front of the Supreme Court just this past Thursday. Along the way, the Chief Justice, including references to the lower court opinions and his dissatisfaction with them in his overall comments about the problems with the government's position. He said the appellate court, that is the D.C. court, did not get into a focused consideration of what acts we are talking about or what documents we are talking about, and suggested along the way, as did other members of the Supreme Court, that what has to happen here is we need further proceedings, which also gives life to those who argue that what this is really all about is extending the time so that this trial cannot happen at any time in this calendar year, almost now certainly prohibitive in terms of the calendar. But further proceedings back in front of Tanya Chutkan, presumably to flesh out some of these documents and the acts we're talking about, and presumably once again to put into action, for the first time in our nation's history, some distinction between official acts of a president and personal acts of the president, even though they are, as Michael Dreeben often said during the course of this oral argument, completely integrated as a part of a conspiracy to overturn the election results. The Chief Justice saying further proceedings are needed, and for that reason, also almost certainly sending this case back down to the district court for whatever those further proceedings might be. Along the way, we also know that Justice Gorsuch similarly raising concerns about things that he sees as specters out there. He describes the concern about a president who could self-pardon. It seems to me, he says, like one of the incentives that might be created is for presidents to try to pardon themselves if indeed there is the prospect of criminal prosecution. Once again, that's never happened in our history. And the Chief Justice, like Sam Alito, engaging there in a very cynical view about what government does and should do. An awful lot of people on both sides of the political aisle, when it comes to pardons, as we have discussed on this broadcast in the past, recognize that the pardon authority is not a reflexive authority. That is, the president cannot pardon himself, recognizing again in the same breath that there is no check on that perhaps Donald Trump, if he becomes the next president, could indeed do just that. But that authority, and implicitly, if not explicitly, saying that that authority exists to pardon yourself inside an official argument before the Supreme Court also sends the wrong messages about civics, about government, about how our government works to all Americans. And beyond that, underscores this fundamental notion that pardons should be the product of a deliberative process inside the Department of Justice, which is where Michael Dreeben comes from. There is an Office of the Pardon Attorney that makes recommendations to the president about those pardons that should be granted, clemency that should be granted, those petitions that should not. All of that, likewise, a disingenuous argument. Along the way, as wrestling with this attempt to identify a rule or a set of standards, get back to Justice Alito. He says, I'm proposing a broad principle to distinguish between official and unofficial conduct. Suppose, he says, the rule were that a former president cannot be prosecuted for official acts unless no plausible justification could be imagined for what the president did, taking into account history and legal precedent. Wow. Justice Sotomayor jumps all over that, saying that plausible is little different from absolute. What is plausible about the president insisting and creating a fraudulent slate of electoral candidates, she asked. Indeed, underscoring this impossibility, Justice Alito, Justice Gorsuch, Justice Coney Barrett, Chief Justice Roberts, and others of articulating a standard here that makes some real sense. And so the question comes, what do we do about all this? In the last segment, Gene called in and asked, what kinds of things should we do in response to this? Well, a couple of things we're going to offer about what may happen down the road in June and the opportunities that we have citizens to become involved in this very process as our discussion here on Amicus, a law review, continues on this, our weekend show. This is Amicus, a law review. My name is Jim Santelle, and we are talking all about this oral argument before the United States Supreme Court in Trump versus United States of America. Gene called in a while back and said, well, what do we do about this? What kinds of things can happen? Let's take that issue up right now. Now, we know from the past that oral arguments are pretty good predictors. Not always, but usually reading the tea leaves got a pretty good sense of what's going to happen. We knew, for example, on December 1 of 2021, the day that the oral argument was conducted in the Dobbs case, 6 months before the Supreme Court actually decided the case on June 24th, almost 7 months, June 24th, 2022, when Sam Alito wrote for the majority in that case that a privacy right to reproductive rights, to abortion, no longer is inside the Constitution, was never there, he says. Wrongly decided Roe versus Wade in 1973. We knew from the oral argument way back in December of the previous year that it was highly likely the Supreme Court was just about to overturn Roe versus Wade. We are in a much compressed time period right now. And yet, sometime in the next 6 weeks, there are opportunities. There are opportunities both inside the court and outside the court. It is possible. And this is why I am hopeful. I am hopeful still. A small portion of me intellectually embraces the notion that members of this Supreme Court, after hearing these things out loud, or at least maybe more than just the three, maybe more than just Sonia Sotomayor and Ketanji Brown Jackson and Elena Kagan, maybe a John Roberts, maybe an Amy Coney Barrett, which gets us up to 5, maybe they go back and they say, you know what? Some of this is a bridge too far. It's plain from the tea leaves reading from this oral argument that the others may be all in on this notion of sort of a bifurcated personal and official capacity analysis. But maybe they sit down, especially if they view this oral argument as a test run, if you will, for a theory that is ridiculous. For a trial balloon sometimes happens, not so much in judicial circles, but in other circumstances of government. Let's see how this plays before we embrace the entire concept. Let's do comments on a proposed rule. That's a part of our routine process under something called the Administrative Procedures Act. Let's see how this would play out. Is there a possibility that the Supreme Court was entertaining these ridiculous notions on Thursday just to see how they would fly? And in the wake of that, as soon as Thursday and afternoon and Friday and this weekend and in the weeks ahead, if the response by the American public is as animated as it should be, and the Supreme Court hears, and they do in fact live in the real world, not just from editorialists in the major publications of our nation, but from people across the country on radio broadcasts like this and others, that this is not a tolerable road to pursue. That if indeed the Supreme Court is going to identify any bucket of criminal activity in which the chief executive can engage with impunity, we are indeed beginning to revoke, if not revoking, rescinding completely the fundamental structures of a republic and of our Constitution. Maybe they sit down among themselves and say, we are hearing from enough people, and enough people on both sides of the political aisle. Everybody should be equally concerned about what we heard on Thursday, if in fact that message is heard by them, whether they internalize that or not, in external conversation among them, and say, you know what, that was interesting. Maybe we do go back and need to write the 2-paragraph order that the Court of Appeals expanded into many, many pages, and the district court expanded in many, many pages. It basically says this is ridiculous. And we entertained this oral argument, but not for the idea of seriously entertaining it, but just to explore all sorts of avenues here. I hold out little hope that will happen, that self-analysis, that self-examination inside the Supreme Court will happen. But that's what's going on right now. After this oral argument now, they are sending around drafts of an opinion, a majority opinion. Plainly, there will be scathing dissents, if indeed this happens as we think it may happen, from the majority opinion, scathing dissents opposing what the majority opinion is saying. Those dissents will be scathing in their content and in their tone. And maybe just as that process goes ahead and these drafts are exchanged internally, a process that we do not see, maybe during the course of that process, a John Roberts, maybe an Amy Coney Barrett comes to their senses and says, no, let us reaffirm the fundamental notions upon which our government has been predicated, As to these other matters involving Donald Trump, we've already told him in the Colorado case, he is on the ballot. We will likely tell him in that Fisher case we talked about before that the underlying statute that underlies 2 of those 4 counts may be subject to attack. Go ahead and give Donald Trump, if you're going to do that, the victories, if you will, in that case, and let Tanya Chutkan wrestle with the consequences of an unfavorable decision in Fisher. But don't do this. Don't do this. This is a bridge too far. And so how do we go about affecting, to Gene's invocation and question, how do we go about doing this? Well, we know that the process of impeachment is almost certainly not an option. It cannot happen under this present political situation. Resignation is not going to happen as well. So those kinds of things. We know that this president early on in his term commissioned a group to look at the Supreme Court, and they came up with some non-decisive results of their examination, but including options for, yes, indeed, increasing the numbers of Supreme Court justices. Perhaps even there's legislation by Sheldon Whitehouse in the United States Senate and others to limit the terms of senators. And that may seem contrary to the content and the words of the good behavior clause of the Constitution, but that too should be pursued, perhaps not as quickly as one would like in the next 6 weeks, but as long-term attempt to address this kind of behavior, if indeed the Supreme Court is going down this road. More significantly, what can we do? Education and advocacy. How about letters? How about writing letters to the Chief Justice, to Amy Coney Barrett, to other members of the Supreme Court? Send them a letter and tell them that you're concerned about the future of our nation. Tell them that we're concerned about undermining the future of a republic by establishing an imperial presidency and going back to King George, which we have not done in 240 years. Talk with them, if you will, about their own traditions in recent times of limiting the powers of the presidency when it comes to things like reducing and eliminating student loan in the education department, finding that's a bridge too far. The president cannot do that. Finding that the president cannot limit the exposure to employees in large companies to COVID. President can't do that. They invoke something called the major questions doctrine, saying that goes too far. The president does not have those capacities to do that. They have limited the Voting Rights Act in 2 major cases called Shelby County and Brnovich, the second of which authored by Sam Alito, finding for the first time in our nation's history that fraud may be a reason to impose limitations and restrictions on voting in America, an incredible notion written into the opinion in Brnovich. They have limited in recent years the Clean Air Act, the Clean Water Act, again, as inappropriate exercises of executive authority. Invoke those and tell members of the Supreme Court that if they are consistent with those views about a limited presidency, you cannot both do that and at the same time vest in the same person who does not have these other powers to, yes, indeed, take care that the laws of our nation be properly executed and properly informed in terms of the execution by the agencies. If you cannot do all of those things, you certainly cannot, in the next breath, grant that person any form of immunity for criminal acts that might be involved in the execution of that work. Send them letters, and beyond that, send those letters to others in government. Support Sheldon Whitehouse. Support our own senator and maybe senators, our own congressmen and women who might be willing to acknowledge that this time the Supreme Court has gone too far. Send our elected representatives letters so that they too can be a part of the voice against this in the public. Write a letter to the editor of your own newspaper explaining the seriousness of this and explaining why it is that this is about the future of our nation and the Supreme Court appears to be getting it wrong. Do it now. Do it now in the next few weeks before in June we come back together on this broadcast and others and talk about the implications of an order that articulates in some imperfect way a standard for the assessment of what is public and what is official and what is private and what is personal, and on that basis make a determination about whether or not criminal conduct inside a presidency can be supported. All those things, the advocacy, the education, talk to young people, talk to middle-aged people, talk to older members of our good community who should be concerned about this, who vote again in August here in Wisconsin, and certainly in November here in Wisconsin and around the country. Talk with them about the importance of voting and the importance of that voting being predicated upon a government that does in fact have checks and balances, where no one is above the law, that everyone is subject to the laws, and that there is not such a thing as an imperial presidency or a king who happens to live in the White House. We have Mark on the phone. Mark, appreciate your waiting, appreciate your call this morning, your comment or your question about our examination of this Supreme Court argument.
Yeah, I guess it's no longer shocking to me that we hear some of these people on the Supreme Court, that not adhering to the fact that the president is subject to the law, to even entertaining, let that be entertained, that the president is above the law, because it's clearly, Hamilton clearly lays out in some of the Federalist Papers. In 69, he says the president shall be, amenable to punishment and disgrace, which clearly indicates to me, at least, that the president is subject to the law. They go on to describe, a man that might, and he goes on to describe a man in I think, 75, where a man of avaricious or self-aggrandizement, might seek to use the office, for his own personal benefit. I mean that, and even monarchs in English history were actually subject to the law. An example I bring up is Henry II, when he had, that just made the off-flip comment, well, somebody remove this priest, and his household knights went there and murdered Thomas Becket, and Henry II was punished for his words. I mean, Charles II ignored Parliament, and Charles I ignored Parliament and lost his head. James II, got into a tussle with Parliament and lost the monarchy.
Right, all those things, Mark. Again, you make reference to the Federalist Papers, in addition to our own history from Great Britain, from England as well. Federalist Papers replete, as you are indicating, with these notions. It is implicit. We do not have to say that the president has immunity or does not have immunity, because it's understood in virtually every single page of those documents written by Alexander Hamilton and James Madison and John Jay at the start of our nation. That too is a resource for our United States Supreme Court. That too should also be a resource for the kind of advocacy that I'm advocating when it comes to writing letters, informing our public, and doing those other things in the times just ahead that push back on this ridiculous and unfounded notion that somehow an immunity of any kind inheres in the executive branch of the United States government. It is an incredible notion. And again, all of this to underscore the possibility that the Supreme Court may still come to its senses, if you will, and not do this. But if they do, what are the consequences of those? And how do we implement this strange new regiment in our constitutional democracy, our republic? How do we go about putting that in place most immediately for a trial before Judge Tanya Chutkan that no longer will happen in this calendar year, will not happen before this election? And how do we do it down the road for all the other implications that Joe raised before? What are the consequences of this? Invoking the Supreme Court's own invitation to think about the next cases, the things that the Supreme Court did want to talk about. What are the next implications for this down the road? How does that play out? All of that for your continuing consideration, and all of us here on Amicus, a law review. This is Amicus, a law review, and my name is Jim Santelle. In this, our final segment of our 2-hour weekend broadcast, thank you once again for joining me in this discussion, focusing almost exclusively upon this all-important, hugely significant Supreme Court argument of just this past Thursday. We know that in another court of the land, very much related to this oral argument about the power of a president and the things that he would do, he or she may do in the executive function, and also those things that someone who is a candidate for president might do in advance of the election. We know that Donald Trump, right now, continuing to be in trial in front of Judge Juan Merchan in that Manhattan trial, sometimes called the hush money case, the catch and kill case. In fact, it's violations of 34 different counts alleged in an indictment, once again, a grand jury indictment, alleging a payoff to a woman named Stormy Daniels for being quiet, keeping quiet about an alleged affair. And in that connection, plainly in the wake of the initial presentation by the prosecution on this past Monday, and certainly in the wake of the testimony, principally of a fellow named David Pecker, the principal theme of this trial comes through loudly and clearly that while there may be some salacious elements of this, and yes, indeed, it is not the case that we're there to try whether or not there was a sexual relationship between Donald Trump and Stormy Daniels. That is not the case. We're here to determine whether or not there was a violation of state law, and that the motive for that, as the prosecution is articulating, was election interference, much as it is in the argument in front of the Supreme Court, maybe ultimately in trial before Judge Tanya Chutkan. Along the way, the prosecutors identifying that as a principal theme and articulating this notion that witnesses and documents will corroborate, will support that theme, and indeed that's exactly what happened. Some comments generally about David Pecker and his testimony that occupied most of the trial days, not exclusively. There were a couple of more witnesses at the very end of yesterday's proceeding. One of them was a woman named Rona Graff, who you may recall, Donald Trump's executive assistant. She sometimes appeared when NBC put Donald Trump on the airwaves for 14 years in The Apprentice. She sometimes appeared as his executive assistant in that broadcast. She testified that on at least a couple of occasions, she was making contacts with both Stormy Daniels and Karen McDougal, and included their contacts in the official databases of the Trump organization. She's no longer on the payroll of the Trump organization, but apparently her legal bills are still being paid. But even so, even though she didn't want to be there, confirmed this seemingly small but nonetheless important corroborating event that indeed there were connections between Donald Trump and the organization and Stormy Daniels and Karen McDougal. We also heard yesterday the testimony of another individual. His name is Gary Farrell. He is beginning to establish the piece of this that focuses specifically on Stormy Daniels. He comes forward and begins to identify some of the records. This is the financial records. This is the stuff that sometimes sounds dry, but it's very significant because he begins to establish the foundation for this $130,000 home equity loan that Michael Cohen took out that forms the basis for the payment to Stormy Daniels. We'll hear more from Gary Farrell next week. And yes, we will probably hear more from Michael Cohen himself. Michael Cohen, when he appears, sandwiched in the middle of this trial, unlike David Pecker, will present some, maybe on the jury, as being a flawed witness, and indeed he is, with a prior felony conviction for lying, other things, and plainly with an animus against Donald Trump. Lots of baggage there. But nonetheless, Michael Cohen will provide additional information about the nature of this transaction with not only Stormy Daniels, but also the prior involvement with Karen McDougal and the so-called doorman. And that gets us to the principal testimony involving this fellow named David Pecker. I would offer to you that for all sorts of reasons, he was a credible witness. Maybe not a likable witness. Don't have to enjoy someone who talks about how the process of journalism in America today involves catching and killing stories that are unfavorable to your clients and advancing unsupported stories for those people for whom you are advocating. But what did David Pecker basically said? He said that this scheme put together by him and Michael Cohen, and yes, by Donald Trump, was designed in principal part to affect the campaign. And he is clear about that. He talks about the fact that in the wake of doing just that, paying off the doorman, paying off Karen McDougal to keep quiet about these stories, one of which was not even true, that in the wake of that, Donald Trump, in a meeting right before he takes the White House, says, I want to thank you for handling the McDougal situation, the doorman situation. Those stories could be very embarrassing, very damaging to the campaign. That's what David Pecker says that Donald Trump tells him about this engagement. And the reason why that is important, once again, it establishes motive, and it also responds to something else that was raised during the course of the opening statements by the defense. defense comes forward and says, you know what, this is not about campaign violations. Oh, by the way, no violations of the law at all, of New York law regarding financial documents. But this may have also just been about keeping this information from your wife, from your spouse, from Melania. And in fact, David Pecker's testimony, in which he describes not only this conversation, but says nothing about Donald Trump being concerned about revelations to Melania, but talks exclusively about revelations to the American public, undermine that defense too. And along the way at the White House in 2017, according to David Pecker, Donald Trump asked him to join him for lunch or dinner. And along the way, Donald Trump asks, how is Karen doing? And once again, expressing interest in the well-being of Karen McDougal. Previously, Donald Trump having said, how's our girl? Using some sexist language there. Donald Pecker responds, she's cool, she's very quiet, no issues. Donald Trump, from the testimony of David Pecker, compelling testimony about the focus of this transaction being not upon keeping your wife in the dark about it, but upon keeping the American population in the dark about this very important issue. Pecker also, of course, coming forward and saying, this is just business. This is a transaction. I like Donald Trump. He's my friend. I still like him. And what does that do? All of these things tend to suggest that David Pecker is a credible witness. You don't have to like him in the literal sense of the word, but he is someone who's providing information that is corroborated, will be further corroborated by Michael Cohen, by these documents that are coming in, by other people, but a very strong witness at the start of what appears to be a very compelling criminal case in the Manhattan trial court in front of Judge Merchan. We'll talk more about that, of course, in future broadcasts. And that brings to the end this broadcast of